Pure Flavel.
Tēnā Mr. Speaker, kia ora tātou katoa. I'm pleased to take the opportunity to represent the Māori Party in setting out our position on this bill. Mr. Speaker, the Māori Party has maintained a clear position on the mixed ownership model from the moment it was mooted, and that is to oppose the legislation which enacts the National Party's decision to sell a significant share in specific state-owned assets. The planned sale of power companies raises issues of ownership and management of fresh water and of other natural resources, which are still under discussions between iwi and the Crown. We absolutely support the well-founded right of Māori to be party to those discussions. We also remind the Crown of its obligation to enter into dialogue with their treaty partner, and I hope to speak to that matter shortly. Mr. Speaker, let me make it clear that we strongly oppose the removal of the 4 state-owned enterprises from the SOE Act and to the proposal to sell 49% of these important Crown assets until historical treaty settlements are concluded with all claimants who wish to include these assets into the redress package. We should not claim not a lot is left in the bucket on one hand while at the same time selling off the resource. Mr. Speaker, our position has been informed by the context of some fundamental kaupapa that the Māori Party believes to, and it forms the foundation of our analysis of the bill. Kaitiakitanga talks about resource management, healthy water, land and people. Whakapapa relationships talks about the relationship between the sea and inland, our commitment to enhancing the well-being of whānau, hapu and iwi. It is also about understanding the interconnectedness between the different elements of our environment. Mana whenua, mana moana, rights and responsibilities. So these are the sorts of kaupapa that give us a Māori worldview and concepts by which we should operate by. And then we must consider the historical context, a history shaped by far-reaching decisions throughout our history in education, land, te reo Māori, in forestry, radio and in television. So it's a history which has helped define our nation, ensuring that Māori have the same rights as others to the protection of law, recognising our unique distinctiveness as tangata whenua and as one of the 2 partners of the treaty. And vitally, it reminds us all of the constitutional significance of Te Tiriti Waitangi as instructing us on how we should live together as partners. So, since the famous New Zealand Māori Council lands case in 1987, treaty protections have kept economic and strategic assets of huge value in New Zealand hands, which have been guaranteed protection by the Treaty of Waitangi settlement process. To arrive at a point whereby that partnership is beginning to be recognised by the Crown through this legislation has taken many, many years, and we have been absolutely determined to follow that through and preserve it. This bill, sir, is a backward step which makes a mockery of a proud history, and in particular Section 9 of the State-Owned Enterprises Act 1986, which declares that, quote, nothing in the Act permits the Crown to act in a manner that is inconsistent with the principles of the Treaty of Waitangi, end of quote. So, despite voting against this bill, we're happy enough with the precedent established by Clause 9 retained in this bill. We fought very hard to the wire to ensure those protections were maintained, but we know that the fight is not over. But while we know that the legislation imposes treaty obligations on the Crown, there are, however, some fishhooks about how the Crown will exercise its treaty obligations. As a case in point, sir, the Crown treaty obligations only apply to the exercise of the Crown's powers as a shareholder. And what would that mean in practical terms? That's pretty much uncertain at this point. Under this bill, the Crown-appointed directors would not be subject to the Crown's treaty obligations. Although it would be unorthodox, it would have been a showing of good faith if this bill spelled out how the Crown's treaty obligations would be met through their directors. Mr. Speaker, these questions have prompted us to vote in support of the some amendments put forward by Mr. Mallard and Mr. Parker at the committee stage, which enabled companies and their directors placed under a mixed ownership structure to continue to be bound by the principles of the Treaty of Waitangi, but it wasn't to be. So this legislation has been a mammoth exercise which iwi Māori have been actively engaged with, and the Māori Party really pays a huge tribute to all of those iwi, and indeed the many 148 submissions, of which many were from iwi and hapu groups, for being prepared to stand up and to be counted. It would be, sir, impossible to summarise these views, but I did want to ensure that this final debate ends with words of iwi. And in this case, I've turned to the submission from one of our own, the Te Ariki, Sir Timu Te Heuheu, on behalf of Ngāti Tū Whare-toa. So, the collective Ngāti Tū Whare-toa position was to oppose the bill on 5 clear grounds, and I'll outline those now. Firstly, they said, Ngāti Tū Whare-toa are the legal owners of the lakes and rivers used by Mighty River Power and Genesis Power. Mr. Speaker, their concern is that the model privatises electricity generation operations on their waterways without them having any say in the matter. They are not prepared to stand by and watch private commercial interest generating private profits from lakes and rivers they own in freehold title. Part 2 of the submission was about the fact that these power schemes were established to generate electricity for the public good, not for private profit. Sir Timu, in his eloquent way, quoted the model expressly enables the privatisation and consequential commercialisation of schemes that were previously operated in the national interest. And I quote, Tū Whare-toa also remarked that it was a very auspicious occasion in 1993 under the national government of the day when Lake Taupo was returned to the hands of Ngāti Tū Whare-toa. So this bill will now urge them to reconsider their position around public free access in light of the likely commercial exploitation of the Taupo waters. The third element I want to talk to, sir, from the Tū Whare-toa submission was that justice dictates the opportunity to reach a fair resolution. Treaty claims should not be foreclosed by the sale of SOEs. Now, this, sir, is a key position for iwi across the Motu, that our rights need to be properly provided for before the sale of any SOEs results in the trampling of those rights. The fourth issue raised was that Ngāti Tū Whare-toa has a relationship with the Crown and is therefore entitled to expect that the Crown will act honourably and consistently with its treaty obligations. This is what they expect as a party to the treaty relationship. Finally, sir, they said relationships with the Crown are critical to the success of electricity generators like Mighty River Power and Genesis, and yet this does not get translated into this bill. Tū Whare-toa described the significant relationships that they have entered into with various land-owning entities and Mighty River Power, such as the joint ownership with Tuaropaki Power Station. So, Mr. Speaker, I want to make it clear we're not here to tell iwi what to do with their money. But I think that the points that Ngāti Tū Whare-toa and indeed many iwi have made in opposing this bill are really important drivers for how the government can expect to work in good faith with iwi going forward. So one of the critical omissions in this legislation is that it does not include a social responsibility requirement as Section 4(1)(c) of the State-Owned Enterprises Act. That section requires each SOE to, amongst other things, be, quote, an organisation that exhibits a sense of social responsibility by having regard to the interests of the community in which it operates and by endeavouring to accommodate or encourage these when able to do so, end of quote. So this has been a really important basis for many iwi in establishing an effective relationship with the entities. It has provided an important balance to the commercial focus of the SOEs and reflects the public good, say for electricity generation for which they were established. So the lesson for government must be to build on these relationships to be socially responsible. Mr. Speaker, I finally want to reiterate the Māori Party's strong opposition to this bill, but also to our commitment to future-proofing the next generation. Thinking ahead is an important pillar to making sure that we look after our natural resources and the management of them. And our customary rights to use resources were found on customary responsibilities to protect, sustain and enhance. So we agree with the analysis by Mr. Brian Gould that the stated reasons for iwi being keen to be buyers in the question of our state-owned assets deserves some attention. His view was that iwi have made it clear that their intention, and here's the punchline, is to buy so that they can hold the assets in trust for future generations of Māori. So in this respect, we have pushed for iwi to have their own share category as tangata whenua, and we know that these negotiations are still in progress. how national response will be an ongoing marker in the relationship they have with whānau, hapu and iwi into the future, we, sir, oppose this bill.
David Bennett.
What?
Thank you,